How's it going, everybody? I'm Jeff Slakey, and I am here with Judge Cadine Ferguson-Brown for another one of our candidate conversations. She's currently the judge here in Mason County Superior Court, was appointed in May of 22, and is running to retain that seat and then for a full term. How are you doing, Judge?
I'm doing well.
Good to talk with you. How's the campaign been going so far?
Well, the campaign has been going well. It's challenging. There's just a lot to juggle, but I'm getting it done.
Yeah.
I'm getting it done.
So you were appointed by Governor Inslee in May of 22 after the retirement of Judge Finley. Tell me about how that process came about. I'm sure there were a lot of folks across the state that were qualified, capable of being a judge here in the county. How did your name get to the governor's desk?
Thank you. So, Jeff, the appointment process is you have to complete this comprehensive application that asks you about your trial experience, your legal experience, your community involvement. It also asks you for references and recommendations and bar evaluations and stuff like that. So in completing that application, you also have to go around and complete a couple interviews with different bar associations so that they can rate you and say whether or not you're suitable for that position. And so I completed all of that process. You also had to provide writing samples of different briefs and pleadings that you've written. And I submitted my packet with the recommendation of the Mason County Bar Association. They had interviewed me along with some of the other candidates, and they recommended me after that interview. I also had references from judges and attorneys who have seen me and how I've practiced and my experience. They're aware of my experience, and they also recommended me to the governor. So after you've completed that, then the governor's office have an interview with you to see if everything they've received match up. So they vet you as well. It's his legal department that did the interview. And typically they would have a second interview, but because it was during COVID or just after COVID, it was just the legal staff that completed that interview. And then they met with the governor based on that. And then they selected the person who was the best suited. And I was the one who got that appointment.
Very interesting. That's fascinating. And now you're finishing up Judge Finley's term here, and then that's where the election between you and the other candidate, Dave Stevens, moves forward from there. Very cool. What has it been like? And I'm fascinated, and I think for most folks on a day-to-day basis, they don't really know any judges. They unless you're, I guess, in the system, really, you would never necessarily be in front of a judge unless you maybe have jury duty or something like that. So on a typical daily basis, as you get ready for your day, how much of the upcoming caseload are you familiar with? Is it like you work Monday, Tuesday, Wednesday, Thursday, and then you get to the bench on Friday doing all your work? Or explain to me how this whole process works.
Okay, so that's a good question. And we do get prep time. We have to plan prep time. But our prep time is not only during the daytime, because during the daytime, things always come up. So a lot of times we're prepping either early morning, late in the evening, or on weekends. So as a judge, we're pretty much working all the time. And so we get our calendars based on the departments that we're presiding over. I'm currently presiding over the civil law matters. And so we have civil hearings on Mondays at 1:30. Or my staff, my court admin staff, they're very good in trying to carve out a couple hours throughout the week where I can sit and see what's going to be on my Monday docket so that I can start prepping for that. Because our judicial code of conduct says whenever we're presiding over a case, we need to be competent. We need to know what is coming. So we have to get that opportunity to prep and research the law, especially if it's a new area for you, because as a judge, you don't know all the areas of the law. There are a lot of areas to know. So you get an opportunity to sit down and prep those. So Mondays are my hearing days, and then throughout the week I have different trials or different contested hearings that I preside over, and that's the process for the civil docket. It's totally different for the criminal and for the juvenile, but we do get time to prep. We do try to carve time out to prep, and a lot of times we're prepping after hours or during the weekends.
I asked your opponent the same question. I want to kind of get your perspective too. It's tough doing these conversations with judges, with politicians, House of Representatives, whatever. You can say, what do you think of this? What are you going to do for that? With judges, it's different, and your opponent and I talked a little bit about this as well. But why is it important that you don't, show your hand is a phrase that I've heard before when it comes to judges out there, so you can have that independence? Is that what is that what the reason is on this?
That's part of it. As judges, we need to promote public confidence, right? That people who come before us are going to get a fair trial. And the way in doing that is where we put aside our opinions or biases, we put aside our beliefs and stuff like that, and we only take into consideration what's presented and then apply the law. If we did it any other way, it would be based on who the judge is. It would be based on my thought process and what I think is moral, right? But we can't do that because we have people having different beliefs. So we have to be able to put aside that and take the parties when they come into court before us, hear their arguments, listen to the presentation, review the facts of the case, and then line it up with what the law says. And that's how we make our decision. So the Judicial Code of Conduct requires that everyone who comes before us have a fair and impartial hearing. And in order for us to protect that and to have and allow for a fair and impartial hearing, we are limited or restricted on being partisan. We're restricted on talking about cases that are pending. We're restricted about talking about controversial issues because then, like you said, you're showing your hand. And so someone who may not be on the same page as you, they're not going to feel that they're going to get a fair shake when they come into your courtroom. And that's the reason why those rules are in place, to kind of ensure that people can have confidence when they enter our courtrooms that they're going to get a fair shake.
One of the things that judges do have a little bit of their own discretion on are the sentencing guidelines and sentencing and things like that. Talk to me a little bit about your thought processes when it comes to minimums, maximum sentencing, alternative sentencing like drug courts and veterans court, things like that.
So, while we do have discretions, our discretions are within a certain limits, right? And so with the sentencing guidelines, you are given, based on the type of offense that the person was convicted of, you're given various ranges that which you can sentence the person for confinement. And then you're also given the opportunity, if the person meets the requirements that are set out by the law, to make them eligible for alternative sentencing, you can consider that as well. So for me, if someone is not eligible for alternative sentencing, they're going to get the sentencing based on what the sentencing guideline says, because that's what the law requires of me. Where someone is eligible and that person wants the opportunity to go through alternative sentencing, such as therapeutic courts or the mental health offender sentencing alternative, then we go through and we look at what does the person meet the eligibility, what is the victim input. We also have some screening that takes place, and we see, will this be appropriate for this individual? And if all of those answers are yes, then we order that alternative sentencing. I have presided over therapeutic courts, and I've seen where it works. And I've seen where people have been in therapeutic courts and didn't complete it, didn't get to graduate, and they ended up having to go back and serve their time in total confinement. These are all tools that are given to us as judges as to how we can ensure that justice is served in each situation. And it may look different for some people because that's what the law allows for. And so we have to follow the law and ensure that when we are carrying it out, we're not carrying it out based on biases or based on favor or based on party affiliations or anything like that. We're carrying it out based on the requirements of the law.
How do you run your courtrooms? What do you what do the lawyers get away with? What don't you let them get away with?
Well, one of the things that I've heard so far is that I run a really well-mannered courtroom. My opponent in the candidate, I think it was candidate in the park, commented on the fact that he admired the way I run my courtroom. I believe that respect is necessary and communication is necessary. And so for each of my dockets that I have, I try to communicate to the parties what I'm expecting of them. And so attorneys know what I'm expecting, and self-represented litigants know what I'm expecting. I believe once that is clear, people do what you're asking of them. Another thing that I do with some of my dockets, when I have, for example, dependency and even the criminal law matter, is to have work group meetings. So all the parties come together, all the people who are interested, like the prosecutor, the public defense, the law enforcement, we come together and we talk about processes so that we can have things streamlined and ensure that we have cases moving along. So I like the way I do my courtroom. I have gotten very good feedbacks from attorneys and from self-represented litigants in my courtroom. And one of the things that they highlight over and over again is that they feel heard whenever they get into my courtroom. They get the time to be heard, they get the time to present their case, and they don't feel as if just because they might be the one accused of a crime or even convicted of a crime, they don't feel any less than anyone else. And I believe that's very important because people need to feel respected. That's how we get people to become rehabilitated. You know, you're not treating them as discarded, but as, okay, you committed this crime, now you're gonna have to be responsible for that. We're gonna hold you accountable, but while we're holding you accountable, you get another opportunity to prove yourself. And I think that is important.
She's running for her own full term this time after fulfilling the time from former Judge Finley. Current Mason County Superior Court Judge Cadine Ferguson-Brown. Are you online? You have a Facebook page, or? I
am online, but I wanted to just correct something there, Jeff.
Oh, what'd I do?
So, and this is painful, but I am running to finish out Judge Finley's term this year I have to run again next
Oh.
year to start my own.
My goodness.
I know.
So you've just been an interim this whole time.
This whole time I have to. So this year, this election is for me to finish out Judge Finley's 4 years.
Oh.
And then next year I have to put this on again.
Sure.
To start my own 4 years.
Okay.
So, but
wow.
I know, right? But with that being said, I do have a Facebook account. It's Retain Judge Cadine Ferguson-Brown, and I do have a website. And on my website, you can see all the judges who have endorsed me. Over 70 judges statewide have endorsed me, and I have the judges here for the Superior Court. They all endorse me, and even Judge Finley, who retired, endorses me because they know the work that I put in.
Well, check out those websites, get that information, and Judge Brown, thank you so much for your time.
Thank you so much for having me, Jeff. I appreciate it.